Good afternoon. Good afternoon. My name is Ms. Bhavya Srivastava. I am Assistant Professor at IIMT College of Law, Greater Noida. Today, I'll be telling about critical analysis of three new bills introduced to replace criminal laws. Why this was in news? Recently, the center has introduced three new bills in the Lok Sabha that propose a complete overhaul of the country's criminal justice system. The three bills are set to replace the Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872. IPC, that is Indian Penal Code, is set to be replaced by the Bharatiya Nyaya Sanhita 2023. The CRPC will be replaced by the Bharatiya Nagrik Suraksha Sanhita 2023. The Indian Evidence Act will be replaced by the Bharatiya Saksh Bill 2023. Now, let me tell you what's all in this presentation. To give an overview, we would be covering need for the new bills, Criminal Law Reforms Committee and its criticism, key highlights of the Bharatiya Sakshi Bill 2023, and the news summary. News summary basically means all the news that was around this recent criteria. What was the need for the new bills? To navigate, first we will deal with colonial legacy. All we know is that India was not independent prior to 1947, and the laws, most of them are prior to independence. So, from 1860 to 2023, the country's criminal justice system functioned as per the laws made by the British. The laws were drafted during colonial times and contained archaic language and concepts that might not accurately reflect current social norms and values. Moreover, advances in technology is also one of the main reasons for the introduction of new bills. As we all know that technology keeps on changing and changes are dynamic. The rapid advancement of technology has introduced new dimensions to crime, evidence, and investigation. That is why the mode of investigation is also changed. Also, the forensics have been affected largely. Next is simplification and streamlining. The laws have become complex over time, leading to confusion among legal practitioners, law enforcement agencies, and the general public. Simplifying and streamlining the legal framework can enhance transparency and understanding. Also, we all know that there are many laws that have redundant and also complex in nature, making it difficult for the layman to understand. So, there was a need for simplification of the existing laws to make it easier for the general public to understand. Next is evidence collection and presentation. The Indian Evidence Act was enacted before the advent of modern forensic science and technological tools. It was enacted by Sir James Fitz Stephens and it is an act of 1872 that is nearly 150 years old. So there is also a need to streamline the law according to the current area and current criteria of according to the changing needs of the society. Next is various reports highlighted the need for reforms in criminal laws. There have been various reports and surveys which tell about the need for the new local laws or to be precise for the new criminal laws. The department related Parliamentary Standing Committee on Home Affairs in its 146th report had recommended that there is a need for a comprehensive review of the criminal justice system of the country. It was also pointed out that the Parliamentary Standing Committee, in its 111th and 128th reports, had also highlighted the need for reforms in the criminal laws. Let me tell you something about Criminal Law Reforms Committee. So, the Ministry of Home Affairs, through a notification dated 4th May 2020, constituted a committee to review the three codes of criminal law. Three codes, as I mentioned earlier, were Indian Penal Code 1860, Indian Evidence Act 1872, and the Code of Criminal Procedure 1973. So, to come back, the Criminal Law Reforms Committee was headed by Professor Dr. Ranbir Singh, who is former Vice Chancellor of National Law University, Delhi. Mandate. The mandate of the committee was to recommend reforms in the criminal laws of the country in a principled, effective, and efficient manner. However, as we know that the coin has two sides, so there were also merits and as well as criticism of the recommendations of the committee. Criticism to begin with first was that the committee came under attack for its lack of diversity and the absence of transparency in its functioning. Clarifications were also sought on whether the committee would be able to function independently of the Ministry of Home Affairs or not. So, there are some demerits as well as merits. So, let us read about the key highlights of the Bharatiya Sakshi Bill 2023. Bharatiya Sakshi Bill 2023 is the revamped version of the Indian Evidence Act of 1872, which was drafted by Sir James Fitzjames Stephen. So, Indian Evidence Act will be replaced by bill which proposes changes to 23 provisions and introduces one new provision. It contains 170 sections in total. So let me tell you, initially Evidence Act had 167 sections in total, divided into 3 parts and 11 chapters. Now, the bill permits the admissibility of an electronic or digital record as evidence and will have legal validity as documentary evidence. The ambit of what constitutes secondary evidence has also been expanded to include the following: copies made from the original by mechanical processes, copies made from or compared with original, counterparts of documents as against the parties who did not execute them, and oral accounts of the contents of a document given by some person who has himself seen it. Now, let us talk about bills that were referred to Parliamentary Standing Committee. The bills have been referred to a Parliamentary Standing Committee. The committee will go over and discuss the bills clause by clause. After it has sufficiently deliberated on the bills, the committee will deliver a comprehensive report to the government and will provide recommendations. While these recommendations are not binding, generally the government tends to look at committee recommendations favorably and incorporates many of them. So, let me tell you that before act becomes a law, there are bills which are made for discussions in parliament. It goes to multiple round of discussions. Then after president gives assent, a bill becomes a law. Now, what were the discussions that were held in the parliament? This is a brief gist of those. Number one, after the committee sends in its recommendation, the government will decide whether to incorporate them and with specific recommendations to incorporate. Number two, if there are not many recommendations to be incorporated, the government simply introduces changes to original bills through amendments. If a significant portion of an original bill is being changed, the government might withdraw the bill and introduce a new modified bill. After the bills in their final form are back in the Lok Sabha, they will be up for the debate. The government will need to muster up a simple majority in order to pass the bills. After the Lok Sabha, the bills will go to Rajya Sabha where they will again be debated and put to a vote. So this is a normal procedure in parliament. Apart from special bills, there is a normal procedure in the parliament. Now, this is a cutting of a newspaper article where the Criminal Procedure Identification Bill 2022 would allow the police and prison authorities to store and analyze physical and biological samples, including retina and iris scans of convicts. The bill also seeks to repeal the Identification of Prisoners Act 1920, whose scope was limited to recording impressions and foot impressions of limited category of convicts. The new bill expands the scope of measurements to include iris, retina, signature, handwriting, and biological samples and their analysis. The records can be stored for 75 years. Mind you, 75 years is a very long time and yet it could be safe. It also proposes to record the details of persons detained under any preventive detention law. Opposition says that this can be misused against political adversaries. Preventive detention law also finds a mention in Article 20 of the Constitution of India. If a person with no criminal background is released without trial or discharged or acquitted by the court, all records of measurement so taken shall be destroyed from the records. So, this actually talks about the practical aspects which the Criminal Procedure Identification Bill 2022 would be bringing. This mainly focus on forensic science and areas incidental or ancillary to it. So, it definitely brings a various change in the area of criminal law as far as the prisoners, their rights, etc. is concerned. Now, before proceeding further with the new laws, let us first understand that what were the issues with the previous laws. So, British legacy is one point, as we all know that the old laws were remnants of British colonial rule designed to maintain their control over India's justice system. Now, we know that British were very cruel and biased towards Indians. So there are many provisions which are still there which are anti-Indians. Now, next one is punitive approach. The focus of the old laws was punishment rather than ensuring justice for citizens. We must be aware of various theories of justice such as retributive theory, deterrent theory, reformative theory, etc. So, one believes that criminals should be reformed instead of being punished. So, for those, this is a punitive approach where Britishers only believed in punishing rather than ensuring justice for citizens. Now, third point is outdated. The laws enacted in the 19th century didn't align with modern societal norms, technology, or justice requirement. As we know that change is the law of nature and justice is one which is very dynamic. So, if we are not accurate and adaptive towards the changing technology, then it is possible that our justice might also be served outdated. Next is low conviction rates. The outdated laws contributed to low conviction rates and delayed justice, eroding public trust in the legal system. We all know that our courts have been overburdened with lakhs of cases and therefore the conviction rates are very low. So justice is not properly served to criminals also and the litigants also. So to reduce this, there is a need for the change in the new law to enhance the conviction rates and enforce that justice should be given properly and in a timely manner. Next is gender insensitivity. The old laws inadequately addressed crimes against women and children, reflecting an insensitive approach. This is true in terms of old laws. However, the changes are now required as far as the time is concerned. So we need to move towards a progressive approach in terms of female sensitivity. Complex procedures are also one of the reasons for the repealing of the old laws. Cumbersome procedures and paperwork led to delayed trials and inefficiencies in the criminal justice system. There is a whole lot of drafting concern, paperwork concern. That is why sometimes justice is delayed. Also, misuse of powers can be one of the reasons. The laws could be misused by the authorities to target individuals and curtail civil liberties, such as the misuse of sedition charges. That is why, if we will proceed further, then we will see that the sedition has been repealed from the Indian Penal Code 1860. Sedition was one law that was used as a weapon by the Britishers against Indians. Even though the words were not that much of disapprobation, but Indians were falsely blamed and were punished for those things of which they were not guilty. Next is lack of victim focus. The focus was often on legal technicalities rather than providing support and justice for victims. So this would be a great relief for all of us that the technicalities or the technical glitch which were obstacle in the justice delivery system will now be removed. Next is lack of technological integration. The old laws lacked provisions for utilizing modern technology. hindering efficient investigation and evidence presentation. Limited scope. The laws failed to address contemporary issues like cybercrimes, terrorism, and organized crime adequately. As we all know that this law is too old and these things such as cybercrimes were not there at that time. As far as terrorism has been concerned, it has undergone a great development and it has become an organized activity. So the law, which was there earlier, failed to recognize crimes included crimes concerning cyber crimes and terrorism activities and also organized crimes. So this will be a huge relief if this new law comes into force, then it definitely recognizes cyber crimes, terrorism and organized crimes. Now, let us proceed to the major provisions of the three new bills. Here is a comparative analysis of the three new bills, and the left side mentions the basis on which the comparison has been made. First table consists of the provisions of the first column. Second column consists of Bharatiya Nyaya Sanhita Bill. Third column consists of Bharatiya Nagrik Suraksha Sanhita Bill. And the last consists of the Sakshi Bill 2023. So, to begin with the comparison, first point is replaces. So, Bharatiya Nyaya Sanhita Bill 2023 replaces the Indian Penal Code 1860. Bharatiya Nagrik Suraksha Sanhita Bill replaces the Criminal Procedure Code, and the Bharatiya Sakshi Bill replaces the Indian Evidence Act 1872. So now let's move to focus. The focus area of Bharatiya Nyaya Sanhita Bill 2023 reflects Indian ethos and is justice oriented. However, Bharatiya Nagrik Suraksha Sanhita Bill enhances citizens' protection. Bharatiya Sakshi Bill modernizes evidence presentation. As far as the number of sections are concerned, the Bharatiya Nyaya Sanhita Bill 2023 consists of 356 sections in contrast to the 511 sections of the old Indian Penal Code 1860, thus reducing the number of sections into the new law. As far as Bharatiya Suraksha Sanhita Bill is concerned, it is now having 533 sections, out of which 160 are those who have been modified or changed. As far as Bharatiya Sakshi Bill is concerned, it is now having 170 sections, that is 3 new additions. Now, next provision is dedicated to women and children. So, in Bharatiya Nyaya Sanhita Bill, a separate chapter is dedicated to them. Also, the sexual intercourse on the false promise of marriage, employment, etc. has been now made a new offense. As far as Bharatiya Nagrik Suraksha Sanhita Bill is concerned, protection and priority in crimes have been incorporated in the same. Now, let's move further. As far as digital integration is known, now the IPC, old IPC as compared to the Bharatiya Nyaya Sanhita, there is expanded definition of the documents in the new revamped version. As far as Bharatiya Nagrik Suraksha Sanhita is concerned, it incorporates digitization of processes. And as far as Bharatiya Sakshi Sanhita is concerned, it incorporates electronic evidence. Accepted documents also include electronic, digital records, emails, etc. Now let's move to this topic of speedy trials. So, Bharatiya Nagrik Suraksha Sanhita contains trial expedited summary trial for petty offences, fixing the 90-day window for investigation after filing of charge sheet, witness protection scheme to be made by the states, bail after serving one third of the maximum sentence for the first time offenders. Now, as far as Bharatiya Sakshi Sanhita is concerned, it has nothing to do with speedy trials as of now. And as far as Bharatiya Nyaya Sanhita is concerned, in terms of speedy trial, summary trials and time limits have been incorporated. Now, if we talk about victim support, in terms of Bharatiya Nyaya Sanhita, complete compulsory status updates of victim support has been incorporated. And in terms of Bharatiya Nagrik Suraksha Sanhita, protection or timely information has also been made compulsory. In terms of Bharatiya Sakshi Sanhita, video recording of search and seizure operations by the police has been made as a new provision into the new bill. Now, if we talk about the punishments, then the punishments have been modernized as far as they were in 1860. Now they have undergone a drastic change if we talk about 2023. So, in terms of Bharatiya Nyaya Samhita, punishments cover newer crimes and cyber offenses. Since substantive offenses are covered in the Nyaya Samhita, so we don't be having any kind of change in Bharatiya Nagrik Suraksha Samhita or Bharatiya Sakshi Samhita. If we talk about terrorism and organized crime, then the new definitions for terrorism for the first time include property confiscation, armed rebellion, separatist activities, organized crimes, etc. They have been made separate offenses. Mob lynching has been made an offense explicitly. We were aware that there have been various incidents of mob lynching where innocent people have died and there was nobody to be held accountable. So, this is a huge relief in order to curb such incidents of mob lynching whereby one loses his or her family member. So, this is definitely a great step. Now, if we talk about Bharatiya Nagrik Suraksha Samhita, there have been harsher provisions against the gangs, that are the offenses that are concerned with people who belong to gang particularly. And as far as Bharatiya Sakshi Adhiniyam is concerned, now it defines and addresses organized crimes. Now let's move to FIR, that is First Information Report. Now, the Bharatiya Nyaya Samhita also incorporates provisions related to zero FIR and EFIR. So, zero FIR and EFIR were popularly known, but they had not been given any statutory recognition. So, these two terms now find place in the modern revamped version of the Indian Penal Code, that is Bharatiya Nyaya Samhita 2023. Now, if we talk about Bharatiya Nagrik Suraksha Samhita, the terms zero FIR, EFIR have been introduced, and they also introduce community service as a punishment, which is one of its kind. Now let's move further to the Bharatiya Saksha Dinam. So mandatory digitization of FIR, charge sheets, etc. and mandatory use of forensic services for offences punishable with 7 or more years has been made. So now if we are definitely moving towards a digital India and we have moved very forward, so why to be left behind in terms of crime or criminal law? So now everything such as electronic records would be uploaded online. We also have a provision of uploading of FIR within 24 hours of its registration. So definitely mandatory digitization of FIR has been incorporated in the new law. As far as sedition law is concerned, it was initially in 124A section of Indian Penal Code 1860. So it talks about that if any feelings of hate or enmity or disapprobation towards the current government are expressed in order to throw it away or incite hatred towards India, then the person concerned would be punishable of sedition, and the punishment was very cruel. So now this sedition law has been repealed from the Bharatiya Nyaya Samhita 2023, making it a sigh for people who are misled in terms of freedom of speech and expression. So now people are free to express their opinion, but the condition remains the same. It should not be against the integrity and unity of the nation. Now, let us first understand what is the significance of the changes which are brought about by the new bills or which the new law aim to bring. So, the new laws aim to expedite justice delivery while protecting citizens' rights and addressing modern challenges. They emphasize accountability, digitization, and justice rather than mere punishment. In May 2020, an expert committee led by Ranveer Singh was established to propose the reforms in the realm of criminal law. Now, if we discuss further, then this is of great significance since we all have seen that the laws have undergone a huge change in terms of labor law or any other thing. but our criminal law is nearly more than 150 years old. If we talk about IPC, it definitely needs a revamping of in terms of laws. If we talk about criminal procedure code, there are processes which were there in the times of 1973. However, with the technological advancement and new methods and machineries, justice can be served in a more efficient manner. Since the IPC is the substantive law and CRPC is the procedural law, and evidence being a linkage between both of them, they all needs to be revamped. We cannot do that if we reform only IPC or if we reform only CRPC, that is Criminal Procedure Code. We need to bring changes in all the three laws, otherwise one would be incomplete without other. So that is the thing which we do, which we need to do in terms of bringing the changes. The new laws not only bring an array of hope in terms of justice delivery system, but also bring hope into the light of justice delivery system as well as administration of justice. Now the abuse of process of court will also be reduced, and definitely citizens will feel more safe and compatible with the new laws which are guiding the nation. Thank you for being patient listener.